Hi, good morning, everyone. This is Rajiv Khanna from immigration.com, the losses of Rajiv Khanna PC. We're going to talk today about whether or not H-1B holders can do business in the United States. And if they can, what are the parameters of that problem? What are the issues that they're likely to encounter? Um, Before I get started, I wanted to um, explain because a lot of people had sent me emails saying, "Can we do this over the weekend?" Because most people are working. And I told them, "Look, what I'll do is I'm going to be recording the call anyway. So if you go to immigration.com, in fact, when you see the recording of this call, I'm showing you. If you go to our website immigration.com, on the right hand side towards the middle of the page, there are links to my blog. I'll be posting this recording in my blogs along with some of the additional material, the graphic that I drew, the kind of infographic, and the memo that I'm going to talk about. So I'll be adding all of those for you. You can just go to the blog, and on our blogs you can actually post comments as well. So if you have questions, I can address them there. You can also join our bi-weekly conference calls. We've been doing it for, I think, 15 years or so. Every other week, we have a community conference call. Anybody can log in. So I wanted to do this over a weekday because otherwise, I just wanted my weekends free. It's kind of difficult. We have a very busy week, so then not have weekends free, then I'm always working then. So with apologies to people who couldn't join, but let's go over, once again, I repeat for people who just logged in, that we'll be doing, I'll be updating all of this on my blog as well. So those of you friends or family who couldn't log in today, they can go review it there. I should have the blog entry updated by Monday or so. Okay. Now, one thing, on your telephones, if you press star five, if you press star five, I can see that you have a question or a comment. We are going to be very informal about our topic. It's a relatively narrow topic. I'm used to having hour and a half long conference calls. This one I expect to last about half an hour to 40 minutes, including your questions. That's my guess. So no worries. We have plenty of time. Go ahead and press star five, star sign and five on your telephone. Again, I remind people who are just logging in, if you have any questions or comments during this call, press star five. That said, let me get started. Okay, I've shown you our website, immigration.com. When you see the screen, when you see the recording, I've actually pointed out on my blog where I'll be posting this recording as well as the accompanying documentation that I'm talking about. So, with that said, let us get started with our conference topic. Okay, question is, can an H-1 visa worker do business in the United States? And when I drew the infographic, I said, well, that depends. The first question to ask is, are you going to invest passively or are you going to work actively? Potentially, they are both possible, but passive business is an easy question to answer. You want to invest in the Wall Street? Please go ahead, by all means. You want to buy 1,000 shares of IBM? By all means, do that. That's not forbidden. If you do day trading, that could be a little problematic. Okay, because now you are using a device that is generating income by you actively participating in that, which brings us to the second kind of business. So, passive business, where you are not actively involved, investing in that is not a problem. How about a private business? How about people have asked me questions like, a friend of mine is starting a company. Can I invest in it? And my answer is yes, as long as your participation is devoid of any management. So if you don't do any management or control, even though you're an H-1B, you can very easily invest. That is not a problem. And if you get income as dividends or as you know what dividends are, right? When company makes profits, they can give you a share of the profit depending upon how much stock of the company you have. That's called a dividend. Or even if they give you any kind of compensation that is not connected with any activity you do, that should be okay. How about active business? That is a little bit more complicated. Okay, I'm going to first tell you what the parameters are. Once again, for people who are calling in late, if you have at any point any comments or questions, feel free to press *5 on your phone. *5. I'll see that you have a question or a comment. And this is a very informal discussion. Don't hesitate to ask a question or make a comment. Absolutely no problem. I would like it to be a conversation rather than a lecture. So, active business, where you actively participate. Now, you've got an H1 with one company and you want to start your own business on the side. What are the parameters? Can you do it? And the answer is maybe, as long as the following requirements. I have mentioned five, but those are just the five basic outline requirements. There's a little bit more to it, and I will get into it in a minute. First of all, you must have an employer and employee relationship with your business entity. What does that mean? That means um, so people are just logging in. Folks, this recording will be available on my blog, so you can always go back and check into it. You haven't missed much. We just started talking. So first thing is, if you want to actively do business on the side while you have an H1B going, or get yourself hired to your own business on an H1B, the following requirements must be met. Before I go there, I want you to know something. You could very well do your H1 through your own business, but you will not be able to process a perm based green card through your business. You can do EB1A, maybe even EB1B, extraordinary individuals. Maybe you can do both those, but you cannot do perm based green card usually through a company in which you are the majority stockholder, even if you're a minority stockholder. Now, we have companies that give occasionally a small amount of stock to their employees. That's not an issue. But where you have substantial share of the company, you could have a problem getting a perm case processed through it. So going back to the H1, what are the conditions you must meet? Number one, you must have an employer-employee relationship with your own company, which means somebody should have the right to control you. What does that mean? So let me give you a scenario which is likely to work. Let's say you have a company, you started a company, you are 100% stockholder or a 51% stockholder. What you do is you first establish a board of directors. Now, different states have different laws. Some require you to have a board of directors, some don't. But in any case, have a board of directors, and usually it can be as few as one, and any number more than one. That board of directors should expressly be given the power in the corporate documents. Those documents depend upon what the corporation is. If it's a C corporation, articles of incorporation, bylaws. If it is an LLC, articles of association, depends upon what category of incorporation you have. But in the corporate documentation, make sure that you get your immigration lawyers who know what they're doing, not just any lawyers, who know what they're doing, as well as your corporate lawyers involved, so that appropriate documents can be drawn which will make your H1B through your own company easier. What are we doing? We are saying the board of directors has the absolute right to remove you from office. Okay. And what kind of office? Can you be, let's say you are a techie, can you be a project manager for the company? Sure, if you're doing IT work, you can be a project manager. But what if you're also managing the company? Well, then you're a CEO. Okay. So if you're a project manager, hire a CEO who can fire you. Does he have to be paid? No limit on how much or how little, or if the CEO or the board of directors has to be paid. There really is no law on this issue. So if a CEO of your company hires you, and you are the owner of the company, remember this, you've got 100% stock in the company. Once again, I'm repeating for people who are just logging in, press *5 if you have a question or comment, or if something is not clear. I could be running too fast sometimes. Just slow me down. Even if you have basic questions, something doesn't make sense to you, ask me. Okay, so if I'm a techie, I want to continue working as a techie, I got to report to somebody. somebody who can fire me, somebody who can control me. If I'm the CEO, I want to be reporting to the board of directors. Okay. And my corporate paperwork should clearly reflect that power relationship. They can't remove me from being the owner, nobody can, but they can remove me from actually working. Okay. So there must be an employer employee relationship, which brings me to the next point. Your business must be some kind of a corporation. Why? Folks, it's a fundamental business law proposition. There was a case, I think, back in the 1890s, over 100 years ago, a case called Salomon versus Salomon, Salmon. Salomon case was the first time where under British law, which is what we are inheriting here, common law, uh, it was decided that a corporation is a separate entity from its stockholders. I could be a multi-billionaire, but my company could be going bankrupt. Creditors can't come after me personally. Why? Because the company is a separate person. That's why when you're an employee of a company, you are working for an entity other than yourself, even though you own the entity. That's what corporate law is. Using corporate law, you create a separate entity, and must not only must you create it, you must preserve it. And I'll get to that point in a couple of seconds. How do you preserve corporate formalities? How do you make sure the company remains separate from you? So you must have some kind of incorporation. Next is, if you are going to work for the company, you have to have an H-1, right? Because if you don't have an H-1, you don't have work authorization to work for that company. Of course, if you have an EAD, I have a question here. Let me unblock. Go ahead. I can hear you.
Hi, Rajiv. Thank you so much for taking this conference for us. I have a question. So you said that, if I'm the owner, I can hire someone to be the CEO who would control me, but I would still be the owner of the company. So what happens in case they fire me or fire the person who has hired them? What happens then?
You see, the way it works is a corporate structure typically is like this. The stockholders can always have a meeting whenever they want. And if you're a sole stockholder, you are a one-person meeting. So you can always fire the board of directors. The board of directors can always fire the CEO, the COO, the secretary, the vice president. So there is a hierarchy of power here. So if they fire you, you can always ask the board of directors to fire the CEO first if the firing is, improper. Okay. And if the board of directors doesn't follow through for you, you can always fire the board of directors in your meeting. Well, it'll be a one-person meeting. It will say, I hereby fire the board of directors and I hire a new one. It sounds pretty silly, doesn't it? But it will not be that silly when there are multiple people involved. We are talking about a smaller operation, what you have three stockholders or four stockholders, then all of this makes a lot of sense. So good question. But if they fire you, you always can get around that and fire them because you own the company. And they can't walk away with your opportunities, your contracts, because ultimately they belong to the corporation and the corporation can sue them. So you will say, well, wait a minute, I own the corporation. How is the corporation suing them? It's really you suing them, but you are acting through the corporation, which is a separate entity. Does that make sense?
Makes sense.
Yeah.
Yes.
Yeah,
Thank you so much.
just think of it as a person you have created. And that person, you will be acting through that person, but it's a separate person. It's not you. Okay. So I'm going to go back to, feel free to ask me again if you have any questions. No problem. So going back to the case of Salmon versus Salmon, where they said corporation is a separate entity, just remember that case and remember that the corporation is a totally different person. Going back to processing a concurrent H-1 or a full-time H-1 or a part-time H-1. Remember, H-1 can come in three different flavors. It can be an H-1 that is completely for your own company. And remember, H-1 can also be for a sliding scale. You can have an H-1 for 20 to 40 hours. Your company is obliged to pay you for at least 20, but they can pay you for more than 20 if you work more. And there's no law that can stop the company from paying you bonuses. So you can have a full-time H1 for your company, a part-time concurrent H1. What does that mean? I've got a job with IBM, but I've got a 10 to 30-hour job with my own company. I had a very interesting case a few years back. In that case, I had a guy who had three full-time jobs at the same time. Now, when he first came to me, he said, Rajiv, can I do three full-time jobs? I want to do three full-time jobs on an H1. And I said, why not? As long as you explain to me the situation. And the situation was interesting. He was a database administrator and he was very senior. So he was doing all this work with Hadoop and some other distributed database systems. So all he had to do was be on call. As long as he was on call, he rarely ever got called in. So he was getting paid by three companies 40 hours each week for being on call. First case we did, it was a simple H1. Second case we did, it was a concurrent H1 for 40 hours, and you can do that. Government asked us how can he work 40, 80 hours a week. We explained what the case was. When we filed the third case, they said, how can you work 120 hours? And again, we explained that his job is not to actually spend 120 hours, but to be available for those 40 hours and each company pays him. So you could actually do a concurrent H1 for your own company, or a part-time H1 or a sliding scale H1 or a full-time H1, as long as your company pays you. Okay, just make sure that your company has to pay you whatever the appropriate wages. And remember, your job has to be related to your field. For instance, if you are a technical person, um, can you be, well, this is a relatively poor example, but I'm trying to think of, let's say you're not a techie, let's say you're a physician, okay? Can you be the CEO of the company? And the answer is, well, it's a little bit away from what you are trained for, but since it is a medical practice, we can probably make a case. But there could be a situation where the person just is not qualified to do the job of a CEO, but they are qualified in their own field. Then they should hire a CEO, have the board of directors hire a CEO, and they should do whatever job they are qualified for. Okay. And the last requirement is that your business must pay you your wages and must comply with all the H1 requirements. These are the requirements all companies have to comply with, and so should your business. Okay. Now we have a question here. Go ahead, please. Go ahead. We can hear you.
Hi, sir. My name is Rajiv. Is that H1 concurrent H1 can be applied any time of the year?
Yes.
Does it has to
Yes.
be 65,000?
Yes, it can. You're not subject to the quota. If you have an H1, doing a concurrent H1 is actually not subject to the quota. Here's another interesting factor, you guys, and I have done this for universities. See, universities have these. I forgot what the name is. They have these special departments where all the entrepreneurs kind of go for advice. Um, we have had people come out of the universities where they have the technology. And here's the interesting thing that you should all remember. Let's say you're working for a university. I'll get to the hand. There's a raised hand. I'll get to it right away. Let me finish my thought. So you're working for a university. Your H1 is a quota exempt H1, right? Interestingly, you can do a concurrent H1 even for a quota job. Very odd, right? There's a gap in the laws where if you are holding a quota exempt H1, you are allowed to do a concurrent H1 even for a quota job. So I have a case where this gentleman is working for the university on a quota exempt H1, and he started his own company, and I think he's going to be very successful. And he owns the company, and we did a concurrent H1 for him for his own company. Okay, so does that make things a little bit clearer, sir?
Yes, sir.
Okay, good. All right. Let's go on to the next. Well, there's a bunch of raised hands. Let's go to okay, there's a whole bunch of them. Let me just go in the order people logged in. So Louisiana, go ahead, please. Louisiana. Louisiana, you are calling from area code 225. Go ahead.
Yeah, hi. I have a question about concurrent H1. So you mentioned we can there was a situation where a person worked on three jobs at the same time.
Yes.
So the primary H1, the first one, does say they are with company A on for their H1. Does company A need to know that a concurrent H1 is being filed by say company B?
The first time around, they don't. But when they do an extension of your H1 or an amendment of their H1, then this issue can come up. Okay. So let's say you're already on H1. Next 3 years, you are good, or the next 2 years, you are good, and you did a couple of concurrent H1s. While you are doing the concurrent H1s, the issue doesn't come up for the attention of employer A. But when employer A wants to extend your H1, I think there's a question on form I-129 that asks which was the last approved H1. Take a look at the form, and if I'm incorrect, just correct me, and we can talk about it some more separately. Okay. So yeah, the company doesn't know the first time around, but they might know if they extend or amend the case. Okay?
Okay, thank you.
You're welcome. All right. Let's go to Texas. Texas, go ahead, please.
Hello, Rajiv sir.
Hello, sir.
Uh, my question is actually, so when I'm doing when I'm planning to do a business, I have to file an H1 for through my company, or can it be can I work for a different company and then have an H1 through them, and then I own my personal company?
If you are going to work for your company, if you're going to do any amount of work for your company, then you are doing actively business. Active business requires you to have an H1. Okay, good luck. Okay, now the last raised hand for this, I think you are on a Skype or voice over IP. Go ahead, please.
Yeah, hi. So I have a question. I have a question on where you said when if you are holding an exempt H1, you can apply for other H1.
Yes, ma'am.
So going reverse, so if someone holds a normal H1, a quota H1, can they apply for an exempt H1 and then go about starting a company or doing their own business?
It's a First of all, that question is very easy to answer. The answer is yes. But my question to you is, can you describe to me a little bit what you're thinking, because it's a little unclear.
Yeah, actually, while I was talking, I just thought that I think I got my answer. So
Okay.
if I'm going through an exempt
Okay.
H1, it has to be
Yeah.
through university. Okay.
Yeah.
Anyway, thank you so much.
Please be my client. I love clients like that. You figure everything out and I just get paid for it. That's delightful. Good luck.
It will be my.
Okay. No, this is not that complicated. Once you understand what the theory is, it's not that complicated. And I'm going to show you the practical applications of it by going to the actual government documents. I'll take 5 minutes for that later on. Now, I wanted to talk a little bit about what is a corporation. I said it's a separate entity. The most important, of course, it protects you from liability as a stockholder. They can't come after you. Another thing is there's a division between ownership and operation. Like I've been saying, I can own the company, but somebody else is operating it. And that's the delight and the beauty of a corporation. So take an example. Again, IBM seems to be stuck in my head today. You buy stock of IBM. You spend $300. You bought stock. You don't get to go to their board of directors and pull up a chair and say, okay, I'm going to run this company. I own stock. There's a separation between ownership and operation. Okay. So insulation from personal liability, I want to bring to your attention one point which is important to remember. Corporation is a very good device from many angles, including insulating you from personal liability. But if you don't treat a corporation as a separate person, which can be a problem for a lot of small companies, especially when it comes to commingling of the funds. If you're putting corporate funds into your accounts, your funds into corporate accounts, there's no distinction, you're going to have a problem. Think of a corporation as a separate person. That's called maintaining corporate formalities. There's a whole lot to it. I can spend an hour just on corporate formalities. In another lifetime, I used to be a business lawyer and I did a lot of corporate work. But here, suffice it to say, be sensitive to that. If you just remember the basic axiom, the corporation is a separate person, you will do okay. The reason we worry about it, there's a doctrine called piercing the corporate veil. Sometimes, under certain conditions, people who claim money from you or want to punish you, they can go behind the corporation and get to the stockholders for personal liability. And typically that happens when there is a lack of corporate formality. The outsiders can argue that, look, these guys don't treat their own corporation as a corporation. Obviously, there is no corporation. Another situation, which is the scary one, and again, I'm not that worried about it. If you do things right, do them by the book. Don't try to, conceal things from the government. Do everything right. I'm not that worried about it. Government can pierce the corporate veil usually a lot easier, especially when they allege fraud or misrepresentation. So be careful with that. I've seen that happen time and time again. We represent companies who are being charged with criminal conduct and fraud, and they are going through the criminal defense system. We help their criminal defense teams. I'm not a criminal defense counsel, but I've done enough of this work to know what the criminal defense lawyers need if they have to meet with the U.S. Attorney's Office, what kind of things they need. So we provide that help. We've been doing it for years. And I know how the government thinks about these cases. So as long as you do full disclosures, I am not worried about you. But if you start making misrepresentations or be negligent about your duties to the government, we can have an issue. Okay. Let's see. So I've covered everything I wanted to cover here. Employer-employee relationship, right to control. Before I go on to the next couple of things I want to cover in 5 minutes, does anybody have any question? Have any question or comment? *5. Press *5. Okay, let's go to the very, very infamous Neufeld Memorandum. In January 2010, government came up with this scheme, which they called employer-employee relationship for H-1 cases. Previously, they had not been that particular or insistent. And I'm not even sure that the Neufeld Memorandum, which contains this scheme, is actually not subject to challenge. It was challenged in Washington, D.C. I reviewed the claims. I thought it was a case that had very little chance of success. Because, see, Washington, D.C. circuit is never the first choice that I have when I go against the government, because this circuit is notorious for being very pro-government, or at least very pro-separation of powers. That's a technical matter. I would rather have filed the lawsuit out of Ninth Circuit or Seventh Circuit. Ninth Circuit is California area, California, Seattle, etc. Seventh Circuit is Illinois, the Midwest kind of area, Indiana. So some of these circuits are amenable to listening to our side of the story better. But anyhow, right now, for the last many years, Neufeld Memorandum has told us what an employer-employee relationship is. I'm going to post this on my blog. When you go to immigration.com, go to the right-hand side, towards the bottom, you'll see my blog. And I'll be making these entries today or tomorrow. It will also be on my Twitter feed. I'll put it on Google Plus, as well as our Facebook page, as well as our LinkedIn page. So you'll have this information when I update it. This memorandum will be there. I want to bring your attention to page 6 of the Neufeld Memorandum. On page 6 at the bottom, is it page 6 or page 5? Give me one. Oh, page 5. My apologies. Page 5. At the bottom, they say the following scenarios would not present a valid employer-employee relationship. Then they go on to tell you, and this just one paragraph has plenty of hints on how you can build a successful case for doing business on your own H-1 for your own company. Self-employed beneficiaries. Now remember, if I have a corporation, I cannot be called self-employed because I'm working for somebody else. Even though I own that somebody else, it is somebody else. Okay. So they give an example. They say this is not an employer-employee relationship, so we won't give you an H-1 for this relationship. The petitioner is a fashion merchandise company that is owned by the beneficiary. So it's a fashion merchandising company owned by the beneficiary. The beneficiary is a fashion analyst. The beneficiary is the sole operator, manager, and employee. So sole operator, manager, and employee. The beneficiary cannot be fired. There is no outside entity which can exercise control over the beneficiary. Okay. So they say in these cases, this tells you, it gives you hints. You should have more than one people involved in the corporation. Paid or unpaid is not relevant. You should make sure that somebody can fire you, and I suggested a structure to you. And then when they talk about this on page 5 and 6 of the Neufeld Memorandum of January 2010, look at the footnotes 9 and 10. They say USCIS acknowledges that a sole stockholder of a corporation can be employed by that corporation because the corporation is a separate legal entity. Okay. Even though a legal entity from its owners and even its sole owner. Good point. That's exactly what we are saying. Okay. However, an H-1B beneficiary employee who owns majority of the sponsoring entity and who reports to no one but himself or herself may not be able to establish that relationship. See, we've been discussing that all the way through, and the government is saying the same thing. And then they talked about in footnote 10 that the appeals office of USCIS has actually given in a number of unpublished decisions the decision that a beneficiary may be employed by the petitioner even though they are the sole stockholder and owner. Okay. But again, the idea is that there's got to be an employer-employee relationship. So these, ladies and gentlemen, is what tells us that government is not opposed to this idea. As a practical matter, we have actually done these cases. Of course, every time we do one of these cases, we go in very cautiously, making sure that we are dotting all the I's, crossing all the T's, doing everything by the book. And if we can do that, it should work out. I have nothing else to add. Does anybody have any comments or questions before we end this call? One question. Okay. Let's go to. Yes, sir. Go ahead.
Hello, sir.
Go ahead.
A quick question. So, if I were to be the business, as in, if I were to hire someone who is a board of director and I own the company as a passive member, and I file my own H1 through the company and follow the same process that you just said, can the board of director be, that person has to be a citizen of US or on a green card or on a EAD? How does that work?
Actually, interestingly, first of all, remember, USA is different than many other countries. Like in India, UK, we have Uniform Companies Act. In USA, every state has its own laws. Okay, so it depends upon the laws of the state. As far as I know, at least in Virginia, there is no requirement, or in DC, there's no requirement that a person sitting on the board of directors has to be actually even resident in the United States. Because these days, with multinational corporations, you have directors all over the world, and they usually congregate through video calls or through phone conferences. So that's something that needs to be checked with your state. When you do the incorporation, you need to check with the corporate council locally. But yeah, I don't see that as a requirement. However, if it's going to be a CEO, I would certainly want them to be an authorized US worker.
Okay.
Remember that I used authorized US worker. So it could be your wife who's on H-4 EAD.
Okay.
Because EAD allows one to work just like a green card does. It has no limitations.
Okay. Because what I was leaning towards is one of my siblings actually has an EAD. through their spouse. And if I were to hire that person as the board of director and I be the CEO in that chain of command, would that be?
Remember one thing, the salaries of CEOs are very, very high. Your company will have to pay you that salary. And that can be quite a tax problem because remember, when the corporation makes money, they pay taxes on it. When they give you a
Right.
salary, you pay taxes on it as well as they do tax withholding. So that money gets chipped into quite a lot.
Okay.
Okay. I'm sure that your CPAs can give you a better idea. My guys, don't take my advice on tax law. I am a total zero on taxes. I barely passed my tax law exam. So yeah, I'm not ashamed to admit it. I find tax law very boring. But we have to know enough about it so that we can get in the experts. Okay.
Okay.
Good luck.
And one more
Yeah.
question
Go
is the way we were talking about is having a primary H1 through an employer and then having another H1 through my own company. What if my primary H1 employer fires me, or I
You
don't
can,
want to
yeah,
continue
yeah.
that H1?
You are in status. You are in status because if you have a concurrent H1 through a second company that is your own company and the primary fires you, you are fine because you still have an H1.
Okay.
Okay.
Okay. Makes sense.
Good questions. Good luck. Okay, there's two more raised hands. Let's go back to Texas. Texas, go ahead, please. Texas. Area code
Good morning,
832.
Rajiv sir.
Good morning, sir. How are you?
Good sir, how are you?
Very well.
My question is, suppose if we are 3-4 H1B holders wanted to start a small scale up, like say franchise of Subway, could we do that?
Only if you are passive investors, because managing one Subway is not a professional job. If, however, you have an MBA or some expertise in business management and you intended to open a string of restaurants or fast food outlets, we could argue for an H1 because you're not just managing one store, you'll be managing the expansion as well. So there are two problems with what you are thinking. Active management will be involved, which is not allowed. Okay. And your degrees will not have any relationship, nor would they be required to run that particular business. Okay.
So even while working at somewhere else as full time, we could not invest and make a passive business, keeping
You
others
can.
running the company.
You can. Passive investment is no problem, but don't go around running the restaurant yourself. Okay. So
Okay.
if you have let's say you form a company called Tom, Dick, Harry, and Sam, the four people who are involved in it, Inc. That company can, not acting through you, but acting through a manager, can buy whatever they want, can hire people, can run things. You can only sit on the sidelines. One easy rule of thumb I've been giving to people for 20 years is this. Think that you have bought the stock of IBM. If you have bought the stock of IBM, whatever amount of control you can exercise of IBM, that's the amount of control you should have over your own company. Or let me rephrase that. Whatever operations you can do for IBM as its part owner should be the same degree of operations you should do for your own company. Pretty much nothing. Okay?
Okay, makes sense. Yeah.
Good luck.
Thank you.
You're welcome. Okay, and the last question of the day. Again, I don't have the IP address. Go ahead, please.
Hi. Actually, you answered my question when you said authorized workers, so that's what I was getting at.
Okay.
If I'm hiring someone, I have to make sure that the
Yeah,
person is authorized to work in US.
that's right. That's right. Well, good luck.
Thank you.
All right, folks. Anybody has any questions before we hang up? Oh, let me just double check. No, this was an old one. Nobody. Okay, very good. We can keep this discussion going on Twitter as well as our Facebook as well as our immigration.com blog. There are many ways. We have this conversation going all the time. But good talking with all of you. Thank you for very, very interesting questions and this discussion. Bye-bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.